Hello, everyone, and welcome back. Go ahead and grab a seat, because today we're taking a measured, careful look at the rules that shape our democracy. This is a We and Law Explainer, and we are diving straight into Episode 2 of our series, Don't Vote in 2027 Without Knowing These Rules. If you caught our previous explainer, you know we looked at how elections are scheduled. Today, we're exploring Sections 29 to 43 of the Electoral Act 2026. This is where the real game begins, folks. We're looking at how politicians actually get their names on the ballot in the first place and exactly how those ballots reach your community.
But before we get into the logistics, let me ask you a critical question. What actually happens if politicians just outright lie on their nomination forms? It's something we've all wondered about, right? How do we hold candidates accountable before a single ballot is even printed? Well, it turns out the Electoral Act of 2026 has very specific answers, and they might actually surprise you.
Now, before we unpack those answers, please take a quick second right now to subscribe to the We in Law YouTube channel and absolutely smash that notification bell icon. Civic education is literally your strongest weapon. By subscribing and clicking the bell, you make sure you stay empowered, alert, and informed throughout this entire election cycle. We have a lot of ground to cover before 2027, and you definitely won't want to miss a thing.
Okay, let's take a look at our roadmap. We are breaking the law down into 4 manageable parts today. 1. The candidate nomination process. 2. Crises like withdrawal and death. 3. Setting up polling units. And 4. Polling agents.
Starting with Part 1, the candidate nomination process, which is governed by Section 29 of the Electoral Act 2026.
This process establishes incredibly strict rules for getting on the ballot. And honestly, this is exactly where community action starts. It gives everyday citizens their first real look at who is trying to represent them. Let's methodically walk through this timeline. Step 1. Under Section 29, every political party must submit the list of candidates they propose to sponsor at least 120 days before a general election. Step 2, and this is a big one, the list has to be accompanied by an affidavit sworn by the candidate at a high court swearing they meet all the constitutional requirements. Step 3, within a few short weeks, the Commission publishes those names and personal particulars right there in the candidate's constituency. So, the crucial takeaway here is that sworn affidavit. It is the community's very first tool for verifying if a candidate is telling the truth.
Now, what's really fascinating here is looking directly at the text of Section 29, subsection 5. What if the community discovers a candidate lied in that sworn affidavit? Well, the law states that any aspirant who participated in that political party's primaries, if they have reasonable grounds to believe the information is false, can actually file a suit at the federal high court. The law directly empowers citizens, specifically rival aspirants, to take a candidate to court to challenge fake certificates or false information.
And the consequences? They are not just a slap on the wrist. If the court determines the information relating to constitutional eligibility is indeed fake, Section 29, subsection 6 is completely ruthless. It states, the court shall issue an order disqualifying the candidate and the sponsoring political party. I mean, I want to say that calmly, but that is a massive legal shockwave. It means total disqualification for the candidate and total disqualification for their party in that specific race. The stakes for lying are absolute.
Moving right along to Part 2, Crises, Withdrawal, and Death, as outlined in Sections 30 to 34.
Look, even the best laid plans of political parties can completely fall apart due to emergencies, and the law has to account for that without leaving room for manipulation. So, can a party just change their candidate if they feel like it late in the game? Absolutely not. Let's compare a valid substitution with an invalid one. Once a name is submitted, a party cannot freely swap or substitute their candidate just because they change their mind. The law bans that. The only valid exceptions are if the candidate formally withdraws in writing at least 90 days before the election or in the tragic event that the candidate passes away.
And this brilliantly illustrates how the law handles those exact tragedies to prevent electoral chaos. Look at this excerpt regarding by-elections. It explicitly states, there shall be no substitution except where a candidate dies, in which case the party shall submit a substitute candidate within 7 days of the death. By enforcing these incredibly tight timelines, the Electoral Act ensures the democratic process keeps moving forward steadily, without leaving a vacuum that somebody could exploit.
There's also another crisis of sorts that politicians sometimes try to create, hedging their bets. But Section 30 briefly and firmly clarifies that this is illegal. It strictly prohibits double nominations. A person shall not nominate more than one person for an election to the same office, and a politician cannot manipulate the system by running for 2 different seats at the very same time. Try it, and you're committing an offense.
All right, Part 3, Setting up Polling Units, which is governed by Section 40.
Let's bring our journey a little closer to Election Day itself. We've talked about the candidates. Now let's talk about the physical voting spaces in your community and how they are legally organized. Section 40 is fascinating because it gives us the literal structural math of our elections. It dictates that the Commission shall divide each local government area into registration areas or electoral wards, and there is a strict limit, not being less than 10 and not more than 20. The Commission then establishes an adequate number of polling units within those wards and allots voters to them. It's like a giant puzzle designed to ensure the voting process is localized and distributed fairly across every single community.
And I really want to highlight this crucial number for you, 14. According to Section 44, the Commission must publish the notice of poll no later than 14 days before the election. This notice must specify the day and hours fixed for the poll, the persons entitled to vote, and the exact locations of the polling units. The law literally demands that you are given at least a 2-week clear runway to know exactly where and when you need to be to cast your vote.
Which brings us to our fourth and final part, polling agents and observation.
Now we transition to what is perhaps the most empowering section of all. Once the candidates are locked in and the polling units are set up, we need eyes on the ground. These agents are the community's ultimate defenders at the grassroots level. Section 41 governs ballot boxes and voting devices. And importantly, polling agents are legally entitled to be present at the distribution of the election materials, including the electronic voting machines. They get to trace them directly from the main office all the way to the polling booth. They hold a legal right to follow the sensitive materials every single step of the way.
So let's deliver a measured checklist of what these agents can actually do to protect the vote. Each registered political party can appoint them, and their rights include being present at material distribution, inspecting the original electoral materials before the election even commences, and observing the voting and counting to ensure nobody manipulates the figures. But, and we must firmly remind everyone of this, while they have the absolute right to observe, they have no right to disrupt the polling unit or harass electoral officers. Order must be meticulously maintained.
So, we've walked through a lot of legalese today, from sworn affidavits to polling unit logistics. But I want to bring this right back to you, the viewer. The law, no matter how brilliantly written it is in the Electoral Act 2026, only works if the community actively enforces it. This entire We in Law explainer is designed to empower everyday citizens like you to demand accountability, vet your candidates, and stand as watchful eyes in your own electoral wards.
I want to leave you with this provocative thought as we wrap up Episode 2. Are you actually ready to protect your vote in 2027? You now know how to check a candidate's affidavit. You know the timelines for substitution, and you understand the powerful yet highly disciplined role of a polling agent. The power isn't just in the hands of the politicians. It's right there in your hands, provided you know the rules of the game.
Thank you so much for joining us for this deep dive. To make sure you are fully prepared and armed with the right legal knowledge for every step of the democratic process, please hit that subscribe button for the We in Law channel right now. And seriously, don't forget to click the YouTube notification bell icon so you never miss an explainer. We will see you in the next episode as we continue to unpack the laws that govern our society. Stay informed and stay empowered.